International cooperation, regional cooperation in combating these sorts of crimes, as we know, it's often emphasized as being central to successful prosecutions. But what does it really mean in practice? We hear a lot of talk about international conventions, UN ODCs, or UN Convention Against Organized Crime, the UN Convention Against Corruption. There are regional agreements, regional conventions, all calling for international cooperation. But when it comes to the practicalities, particularly as prosecutors, the starting point is to first understand how international conventions actually bind us in our own jurisdictions. And it is something that is often not fully appreciated by those who tell you to cooperate better with each other. So, for example, the UN Convention Against Transnational Organized Crime is not really regarded as a self-executing convention. If you read the wording of it, it talks about member states shall pass laws, they shall cooperate, they shall implement provisions for covert surveillance and controlled deliveries and so on. And so when it comes to whether it is self-executing or not, there is a question mark in and of itself. The other aspect, of course, is whether your jurisdiction is dualist or monist in its approach to international conventions. A dualist jurisdiction will require a domesticating legislation to be passed in order for those international conventions to have full impact. Now, of course, an international convention can be a trigger for a bilateral agreement. So I, as Sri Lanka, could come to you as Ethiopia, and we don't have an agreement, but I could say, look, we're both parties to this particular convention. Let's trigger a bilateral agreement between us for cooperation. But that's so when we're talking about common law jurisdictions, you will need a domestic law. So the first question for you is, does your country have a mutual legal assistance law? And if not, in order to give effect to these international calls for cooperation and regional calls for cooperation, that has to be the priority, is to get a domesticated law on mutual legal assistance. I think all of you have extradition laws, but not all of you have mutual legal assistance laws. There are plenty of guidances available. UNODC has a model law on mutual legal assistance. It's not perfect, but it's a starting point. And you can borrow from each other's laws where they exist to come up with something that is suitable for your own jurisdiction. But that has to be the priority. If you don't have a mutual legal assistance law, like South Sudan, for example, you have some difficulty. And everything's going to have to be done on an ad hoc, bilateral or multilateral basis, depending on how many countries you need to cooperate with. If you're a monist jurisdiction, so for example, Angola, international conventions are often regarded as having automatic application. But again, it will then depend on the wording of the convention. Is it self-executing or not? So as a prosecutor, when you are looking at a call for mutual legal assistance with another country, you must first look at whether they have a domestic law or not, and if not, what is needed to trigger the sort of agreement that you need to have in place in order to execute that mutual legal assistance that you require. Sherlock, S-H-E-R-L-O-C, the UNODC sort of database of laws, is an excellent starting point again. So you can find the laws of most jurisdictions on there. And then, of course, most of these things come down to human interaction. That's what this network, this association is so important. You're all meeting each other. Hopefully you will exchange phone numbers and contacts. And so if there is a problem, you can phone each other up. And most challenges I've faced both in practice and working in this jurisdiction for the last 10 years, in Kenya anyway, most problems with mutual legal assistance have actually been resolved when somebody says, oh, hang on a moment, I know a prosecutor in that service, I'll give them a call. So the relationships that you're making through these networking events, I'd encourage you to exchange cards, to keep that contact list and to communicate with each other once we're out of this conference, because those relationships are actually what will make these requests move more quickly. And also when it comes to issuing a letter of request, it is far better to phone up, for me to phone Ethiopia in advance and say, I'm sending you a letter of request. Have I got it right? Is there anything that I'm missing? Before I formalize it, get it all certified, authenticated, and so on. To get that right at the beginning, simply by having a discussion with my counterpart in Ethiopia or Uganda or Tanzania. Now, another aspect I just want to touch on, because we are talking about serious crimes, is as prosecution authorities, again, I think sometimes many organizations supporting your work forget how young we are in many jurisdictions as independent prosecution authorities. There are many jurisdictions across Africa where the prosecution authority has been only recently separated from the Ministry of Justice or the Attorney General's office or the state. Some jurisdictions in this room where that hasn't happened yet. And so as an independent prosecution authority, in order to tackle any crime, it is essential that you have the right policies and foundation in place. Because many of your prosecutors may be quite junior, you may have undergone, like Kenya has had a massive recruitment over the last few years. It's a huge intake of new prosecutors into the service. He may lack some experience. And so for any prosecution authority to properly both prosecute these sorts of crimes, but also assist another jurisdiction in determining whether a crime has been committed, whether it falls within their domestic mutual legal assistance laws, the prosecution policies are vital to have in place. And the most important one is the decision to charge. The decision to charge guideline, which was issued by Kenya first, I think, in 2013 and then revamped in 2019, is the bedrock, the foundation of every single prosecution, whether it is a shoplifting all the way up to a counterterrorism charge. And without it, I think many prosecutors can easily find themselves making mistakes and finding themselves criticized because they haven't got an objective, standardized approach to the decision to charge. So for those of you that don't have a decision to charge policy in place, I would encourage you to prioritize it. If you were to look at the Crown Prosecution Service's website, it is on the front page. It is a public document, just as it is for Kenya. It explains to the public why prosecutors make the decisions that they make. And in that way, it means that prosecutors can that you can justify every decision you make, whether it is to prosecute or not to prosecute. And once the public also understand what you're doing, you find yourself, usually I have found in my 16 years of practice, very rarely if I had a complaint about a decision not to prosecute a case, because the victim, the witnesses understand very clearly why that decision has been reached, and it makes sense. It also protects you from allegations of incompetence or corruption, which are terms that are very often slung around in response to decisions that perhaps particularly vested interests may not be so happy with. So the decision to charge policy that was passed in 2019 by the Kenya ODPP is a fantastic document. It's online. I'd encourage you to have a look at it. Also, the Crown Prosecution Service's decision to charge guidelines. It's called the Code for Prosecutors. I'd encourage you to have a look at it if you don't have anything of the same in your own institution. And there is no need to reinvent the wheel when it comes to developing these policy documents. As a prosecutor, if you're handling an organized crime offense, whether it's wildlife trafficking, marine crime, drugs, anything else, you're always going to start with looking at, is there sufficient evidence? And then usually you will look at whether it's then in the public interest to prosecute. That's all it is. But usually when you have these decision to charge policy documents, they're accompanied with much more detailed guidance, and you can give bespoke detailed guidance for then these types of crimes. So you can have the basic policy and then layer on top of it specific advice for certain types of crimes. And again, if you look at the UK's CPS website, you will find guidelines for virtually every type of crime, or these most serious types of crimes, because different crimes have different considerations. And as a prosecutor, that was always where I would start, particularly if I wasn't experienced in a particular type of crime. It was a very, very good starting point. So the decision to charge is vital. And one way that the Kenyans were able to put this into practice to tackle another problem, which is often, I'm sure many of you will identify with, delay in the criminal courts. They piloted the decision to charge policy in certain courts to clear an enormous amount of backlog of prosecution cases that had probably died a death in and of themselves many years ago, but were still stuck in the system. And so these guidelines were piloted, I won't say piloted, but they were used in certain courts to get prosecutors used to using them and to clear a lot of backlog, which has then freed up those courts for these more serious crimes, which of course is so serious. I think what many outside parties forget is that few jurisdictions have specialist courts for these types of crimes. We don't have the resources, we don't have the personnel. And so we take all of these complex investigations and prosecutions and they enter the same bottleneck of a court system, which is awash with crimes that might be years old. It's awash with robberies, shopliftings, minor offences, complex offences, and then that's often where they will get stuck. And so case backlog is a challenge in many jurisdictions, particularly for serious crimes. They're going to take a lot of time. But one thing that a prosecution service can do is stop adding to it, and that is through application of an objective decision to charge policy, and also use that decision to charge policy to actually get rid of a number of cases that shouldn't be there in the first place. And only then, I think, can you start to see these more serious crimes start to move more quickly. As prosecutors, just remember, you are the gatekeepers to the criminal justice system. It is not the investigator, it is you. And so the way that you let cases in or don't let cases in, or when you let those cases into that system, must be done according to a very objective, clinical, forensic approach to these cases. And I think you'll struggle if your jurisdiction doesn't have that policy in place for you to rely on. So I'm going to stop there. I don't know if